This is Colin O'Keefe here for LXBN TV. In an interesting Facebook firing case coming out of New Jersey, it was found that an employer was just fine in firing an employee for a status she privately posted to Facebook after the status was relayed to them from another employee. Joining me to explain the details of the case and the lessons we can learn from it is Sarah Hudgens-Jadka. She is an attorney with Porter Wright, and she is author on the firm's blog, The Employer Law Report. Sarah, first, can you explain the basics of what happened here? I understand the facts are quite interesting.
They are. Well, in this case, Deborah Ealing was a paramedic and nurse, and she was hired by Monmouth Ocean Hospital Services Company. It's MONOC for short, and they provided emergency medical services. Well, she had a Facebook account, like most people, and she made a post about a shooting at the DC Holocaust Museum. And basically, she implied in that post that the paramedics arrived too soon and should have let the shooter die. Well, unbeknownst to her, one of her coworkers, who was her friend on Facebook, was taking screenshots of her Facebook post, of her wall status, and he was forwarding them to one of the managers at MONOC for whatever reason. It doesn't look like the employer was asking for him to do this. He was just kind of doing this on his own. This employee, the plaintiff, had made allegations against the company before and tried to, do other things to help, other employees and things like that. So it's unclear why he was doing this, but nevertheless he was. And they decided to suspend her with pay because they were concerned that the post showed a deliberate disregard for patient safety. Now, she was later fired for some other reasons, and after she was fired and whatever else, she first filed a charge with the National Labor Relations Board, saying that their accessing these Facebook postings invaded her privacy. The NLRB came back and said, well, these were unsolicited by the employer, so they weren't really asking for these, so they didn't really invade her privacy. So she lost at that level, and what she did then was she filed a charge with the district court in New Jersey. She brought a few other claims, but the ones that were most important for our purposes were the claims under the Stored Communications Act and under New Jersey common law invasion of privacy. What made this case very interesting, because as we are moving into the social media age, not moving in, we're already there, is we haven't had cases that have held or determined whether or not Facebook posts would be deemed communications and within the purview of the Stored Communications Act. Well, this case held indeed that private postings on Facebook are indeed covered under the purview of the Stored Communications Act. The interesting thing about this case was I call it kind of the frenemy case because these were turned over by somebody who was her friend. It was somebody who actually had access and was an authorized user to the posts. And under the Stored Communications Act, there's an exception, and it's the authorized user exception. And they found that this person, this friend, was an authorized user, somebody who this type of communication was intended, and therefore they held that this particular post was therefore not covered by the SCA because it was accepted by, there was an exception based on the authorized user exception.
I see. So second, what are the lessons here? What can both employees and employers take away from this?
I think the first thing that employees need to know is that your public communications are just that, public communication. They're going to be used against you. So if you want things private, you need to learn your privacy settings. The second thing is that private communications are off the table. Employers are going to violate the SCA if they start digging and getting private communications. However, if a frenemy turns them over, so long as the employer hasn't coerced or encouraged someone to turn them over, they're probably going to be accepted under the SCA. So one thing that employers maybe want to be cautious about is how much they actually encourage employees to turn over social media posts. They would more likely want to take a passive approach to these Facebook postings, and they will accept them certainly, but not encourage employees to turn them over. The other one is the NLRB looks like it's going to take the same type of approach. As long as the employer is not encouraging this type of conduct and lets the employees come to the employer with these things, the NLRB looks like it is likely going to say that these were authorized communications and that there was no invasion of privacy.
I see. That's always the interesting part, what the NLRB will do, as this is a very sensitive subject for them. So this will be a really interesting one to watch in both the near and extended future as well. Once again, that was Sarah Hutchins-Jaka of Porter Wright. For her extended analysis of this ruling, be sure to visit employerlawreport.com. And of course, if you're not already watching us here on our site, LXPN, be sure to swing by the new look LXPN.com, where we, as always, have hundreds of these LXPN TV, video interviews, and curated commentary from the Lex Blog Network's more than 8,000 members. Thank you for joining me today, Sarah.
Thank you.